Today we're looking into something pretty sensitive, actually. It's where these really personal, emotional journeys of ending a marriage sort of crash into the state's big constitutional duties.
Absolutely. We're talking about marriage dissolution cases in the Philippines, specifically nullity and annulment.
Yeah, and these are kind of unique, legally speaking, because the state itself is considered an essential party. It sees its job as, well, defending the marriage itself.
And for a long, long time, that duty meant this huge, resource-heavy legal process that affected thousands of people.
Right, that process being the automatic appeal. Basically, if a trial court agreed to dissolve a marriage.
The Office of the Solicitor General, the OSG, the state's main lawyers just automatically appealed it. Every time, no matter what.
Wild. So our mission today is to unpack the massive shift away from that. The OSG isn't doing the automatic thing anymore. They're being selective.
Yeah, they've moved to a discretionary system. We need to look at the history, the old rule, why they made the change, the new policy, and what it all means.
For the courts, for due process.
And maybe most importantly for you, the person actually going through this incredibly tough process.
It really boils down to this tension, doesn't it?
Yeah.
How do you balance the state's constitutional job to protect marriage with, the practical realities? Judicial efficiency, the cost, the emotional toll on people?
Exactly. It's like watching a big institution trying to adapt when it hits capacity limits.
Okay, before we dive deeper, maybe quickly clarify the difference. Nullity versus annulment, because that matters here, right?
Oh, definitely. Nullity often involves things like psychological incapacity, Article 36 cases. These are super fact-heavy, usually need lots of expensive expert evidence, like psychiatric reports.
Right, the really complex ones.
Yeah. Annulment might be about, say, a lack of parental consent if someone was young, or fraud, things like that. But both types, crucially, always required the OSG to get involved and scrutinize them.
Okay, got it. So let's start with that old system, the automatic appeal. Where did that even come from? Why appeal every single decision from the regional trial court, the RTC?
It really stems from the Constitution itself. The Philippine Constitution mandates the state to protect marriage as this fundamental social institution.
Okay.
So the OSG, as the Republic's lawyer, basically interpreted any RTC decision granting an annulment or nullity as something they had to challenge to fulfill that constitutional duty. It was their job to defend the state's interest in keeping the marriage intact.
So is their interpretation of their duty. But was there an actual law saying, OSG, you must automatically appeal?
That's the interesting part. No, not really. There wasn't one specific law spelling out automatic appeal. It sort of evolved over decades. It became an institutional practice based on how the OSG read its duties under the family code.
Huh. So more like a very strong tradition built on their interpretation.
Pretty much a self-imposed extra layer of checking.
And the main worry driving this check.
Collusion. That was the big one. The absolute primary fear.
Collusion. Explain what that means in this context.
It means the husband and wife secretly agree to fake the evidence or the legal grounds just to get the marriage dissolved. Remember, historically, there's no divorce in the Philippines, so the pressure to find a way out can be immense.
All right. So they might cook up a story.
Exactly. Maybe they both agree to testify falsely about psychological incapacity, for instance. They feed the psychiatrist a rehearsed story. The automatic appeal was supposed to be the safety net, the guarantee that an impartial government body double-checked every single case to catch any potential cheating before the decision became final.
I mean, I get the logic behind wanting a safeguard, but wow. The practical side of that, you're essentially saying the trial court, the judge who heard the witnesses, saw the evidence.
Can't be fully trusted on its own in these cases, not until an appellate court has also looked at it, purely because of that risk of collusion.
It sounds incredibly resource intensive.
Oh, hugely. And former Solicitor General Darlene Berbrab actually mentioned that her predecessor really held the line on this policy, which brings us right to the moment things changed.
Okay, let's talk about that pivot, the move to the new approach. Who initiated it and what finally broke that long-standing tradition?
It was Solicitor General Darlene Berbrab who announced the change, and the shift itself is pretty clear. The OSG just won't automatically appeal anymore.
Oh.
Instead, they're doing what they call an initial assessment. They review the RTC's decision first, and then decide whether to appeal. It's selective now. Discretionary.
Discretionary. Sounds more efficient on the surface, but why the change? What was the main justification for abandoning that rigid automatic system?
The number one reason cited everywhere is resource management. This is where it gets stark.
Uh-huh.
Berberet pointed out that appealing every single case was just draining the OSG's resources massively. Think about it, around 20%. 20% of the OSG's entire caseload was tied up in these marriage dissolution appeals.
1/5 of everything the Solicitor General's office does. Wow. Just defending these appeal decisions. But why is reviewing them so draining? Isn't it just paperwork?
Not really. These cases, especially the psychological incapacity ones, are often really complex. You've got detailed psychiatric reports, expert testimony, transcripts.
Right, the evidence is technical.
Exactly. So for the OSG to properly prepare an appeal, they need experienced lawyers to wade through potentially thousands of pages for every single case. Doing that automatically, whether the appeal had obvious merit or not, well, it ties up lawyers who could be working on other critical government cases.
So the argument isn't that they're giving up on defending marriage.
No, the argument is that they're trying to be smarter about it, optimize their resources.
By not appealing the cases where the RTC clearly got it right and there's no hint of fraud.
Precisely. The idea is targeted appeals. Focus the firepower on the cases that genuinely raise red flags.
But what kind of red flags?
Things like clear signs of collusion that maybe the trial court missed, or outright fraud, or maybe an RTC decision that seems way off base legally, like it completely misinterprets the family code or Supreme Court rulings.
So be more effective by being more selective.
That's the goal, making sure the state's interest is protected well, not just often.
It also feels, I don't know, like maybe an acknowledgement that things have shifted a bit. You know, with all the talk about divorce, and sometimes the Supreme Court interpretations seem a little more human-focused.
I think that's part of it too, yeah. The legal and social landscape isn't static. The new policy reflects a need to adapt. Now, the decision to appeal involves a real, substantive review of the evidence and arguments, looking for actual problems.
Okay, makes sense. But let's talk legal basis. If they're not appealing automatically, does the law still require the OSG to be involved at all? Or could they just step back entirely?
Oh no, their involvement is still absolutely mandatory. That hasn't changed. It's grounded firmly in the law.
Which laws specifically?
Well, Article 48 of the Family Code is key. It explicitly says the prosecuting attorney or the soldier must appear in these cases specifically to prevent collusion.
Okay, so that's at the trial stage.
Right. And then there are the rules of court, specifically AM number 021110 SC, which details procedures, including needing that certification from the OSG, saying if they agree or oppose the petition before the decision is even finalized by the RTC.
Got it. And their power to appeal itself.
That comes from the 1987 Administrative Code, Section 35.1, which empowers the OSG to represent the Republic, the state, before the higher courts. So the power to appeal is still there. They're just choosing when to use it now, exercising discretion.
Okay, so this brings us to the big so what? What are the real world implications of this shift for the system, for people?
Well, the most immediate potential impact is on judicial economy. Think about the Court of Appeals, maybe even the Supreme Court. They were swamped with appeals, many of which were, let's be honest, procedural formalities under the old rule.
Right.
Removing that automatic flow should, in theory, free up the appellate courts, reduce their backlog, and hopefully speed up other types of cases too.
Okay, judicial efficiency, that's one angle.
Uh-huh.
But let me push back a bit here. If the OSG says, we're doing this partly because of resource constraints, doesn't that sound like they're saying, we can't afford to defend the sanctity of marriage as thoroughly as we used to? Isn't there a risk they're choosing efficiency over their core constitutional job?
That is the critical tension here. And yeah, that's the counter argument you hear. Critics worry it lowers the guard.
How so?
Well, the concern is, what if that initial assessment by the OSG is too quick? Or maybe not as deep as a full appeal would force them to be? Could collusive cases, or ones based on weak evidence, slip through the cracks now because there isn't that guaranteed second look?
So a potential perception, or maybe even reality, of reduced scrutiny.
Exactly. It definitely shifts the perceived balance of interests. Before, you could say the state's interest in preserving the marriage almost always got priority via the automatic appeal. Now, the individual's interest in getting finality and moving on seems to carry more weight, at least procedurally.
And for the actual person, the litigant, this must feel huge.
Oh, absolutely. Tangible difference. Before, winning at the RTC was like, okay, step one done, but now brace for years of waiting for the OSG appeal to resolve.
Years.
Seriously, it could easily take years for the appeal process. Now, if the OSG does its review and says, nope, no grounds to appeal here, boom, finality, much faster. That saves immense emotional stress and, frankly, a lot of money for the individual.
That human cost of the old system,
Yeah.
just waiting, maybe for years, often just for the appellate court to say the RTC was right all along. That's rough.
Incredibly rough. Now, of course, if the OSG does decide to appeal after its review,
The wait is still long.
the wait is still long, yes. But the key difference is that the decision to appeal is supposed to be based on merit now, not just an automatic reflex.
You mentioned the Supreme Court showing some flexibility even before this policy change, that Murillo v. People case.
Yeah, Murillo's relevant. It showed the Supreme Court was already willing in certain situations to say, look, the OSG's rigid stance here is actually hindering substantial justice for the petitioner. It suggested the system wasn't totally inflexible even then. This new OSG policy kind of formalizes that potential for flexibility system-wide.
Let's bring it back to fairness and practicality then. Apart from saving government resources, why is this seen as, well, fair to the people involved?
Primarily, it's about reducing that burden we just talked about. The automatic appeal felt almost punitive to some litigants. You've proven your case based on, say, severe psychological incapacity. The marriage is clearly broken, yet you face this guaranteed, lengthy, expensive appeal process.
Right.
Using discretion means the system can acknowledge when an RTC decision is clearly justified and let people move on faster. It allows the OSG to focus its efforts where there are genuine concerns, real evidence of collusion, serious legal errors, protecting the state's interest effectively, not just automatically.
It also seems to show more respect for the trial courts, doesn't it?
I think so, yes. It acknowledges that the RTC judge heard the evidence, saw the witnesses. Their decision should generally be presumed correct unless there's a specific compelling reason to challenge it. It respects that part of the due process.
And practically speaking, besides resource efficiency for the OSG, it streamlines the whole judicial pipeline potentially.
Yes, by reducing the load on the appellate courts. But the crucial thing to emphasize here is that the safeguards against collusion aren't gone. They just happen earlier.
Ah, okay. Explain that.
The state's oversight is still built into the trial process itself. Remember Article 48, the prosecutor or the OSG counsel has to be there during the RTC proceedings.
They're actively participating in the trial.
Yes, their job is to cross-examine witnesses, challenge the evidence presented, argue against the petition before the RTC judge even makes a decision. That's the primary firewall against collusion.
I see.
And then there's that mandatory certification from the OSG required by the court rules before the RTC decision becomes final. So the mechanisms to detect problems early on are still very much in place. The discretionary appeal just removes what many saw as a redundant, costly fight at the end when those initial safeguards worked.
Okay, that paints a clearer picture. It's less about abandoning oversight and more about placing it effectively at the trial level.
That seems to be the intent, yes.
This has been really insightful. It's a fascinating look at how a legal institution adapts. The OSG essentially shifted from this really broad, almost default defense of marriage to something much more targeted, based on merit, trying to balance that core constitutional duty with practical realities of limited resources.
Yeah, the key takeaway seems to be it's not necessarily about the OSG backing away from its mandate, but about choosing how and when to fulfill that mandate most effectively. Focusing resources on cases where there are genuine legal issues or potential fraud, rather than spreading them thin across every single case.
Which leads us to a really interesting final thought for you, our listeners, to chew on. If the state has this fundamental constitutional mandate to protect marriage, does moving to a discretionary appeal system driven, at least partly by practical things like resource limits, does that change the actual nature of the constitutional duty itself? Or is it just changing the method used to enforce it? What does it mean for how we uphold core constitutional values when faced with the very real constraints of budget and capacity?
That's a question with implications far beyond just family law, I think.
Definitely something to mull over. That wraps up our deep dive for today. Thanks for joining us.
See you next time.